Hello, everyone. Welcome to IPWatchdog Unleashed, where each week we journey into the world of intellectual property to discuss the laws, news, policy, and politics of innovation, technology, and creativity. With analysis and commentary from industry thought leaders and newsmakers from around the world, IPWatchdog Unleashed is hosted by world-renowned patent attorney and the founder of IPWatchdog.com, Quinn, who has twice been named one of the most influential people in the intellectual property community and recognized numerous times as one of the top IP strategists in the world. Take it away, Gene.
Thanks, Renee, and welcome everyone to this week's edition of IPWatchdog Unleashed. This week, my guest is Andrei Iancu, who really needs no introduction. He is a former director of the United States Patent and Trademark Office. He is one of the preeminent litigators he was prior to joining the Patent Office, and now he's back in the private sector, advising clients and litigating, and then also fighting the good fight with respect to IP policy as he sees it, which we'll talk to him about today. But Andrei, thank you for being here.
Great to be with you, Gene.
One of the things I like to do to try and get people an opportunity to get to know our guests maybe a little bit more than they do already is to go way back to the very beginning of your career and start there. We don't have to go inch by inch through your career, but I think it's interesting to find out what drew you to intellectual property in the first place. How did you become a part of the industry?
You're testing my memory now. Going back to the beginning of my career seems a very long time ago, but I did graduate law school 30 years ago last month, so it's a little frightening to think about, to be honest. You know, before I went to law school, like many of us in the space, I was an engineer. I worked at Hughes Aircraft. I worked on antenna payload, the payload that goes on top of satellites. And, I was in my early mid-20s at the time, and I really enjoyed the engineering work. But for a variety of reasons, I had what I called at that time a quarter-life crisis, thinking about the very long term of my career and so on. And I decided to go to law school. And like many of us with a degree in science or technology and combine that with a law degree, it made most sense when I came out to do IP. At that time, I don't know if you recall, there was a big and old law firm on the West Coast called Lyon Lyon. Went back to the late 1800s. Anyway, so I went and I joined that firm. It was an IP boutique that did all aspects of IP, more leaning towards litigation than prosecution. But I did both at that time, and that's how it took off from there.
It's interesting, Lyon Lyon, that's a name I haven't heard in a long time. And there's been so many firms, the big firms that were there for 100 years that just vanished. And now there's big firms in their place. It always seems like in our industry, there's this process of getting big and then getting small again, and getting big and getting small again. And it seems like the big, giant general practice firms all want to get into intellectual property. But then they get into intellectual property, and I don't think they really know how we fit into the program. I suppose you litigating types, you fit better into their billable structure than the prosecuting types. But have you ever stopped and thought about just like it almost feels like the industry breathes. It sucks air in and then it lets air out, and it's always changing.
Yeah, I thought about it a lot, Gene. I was the managing partner of my firm before I went to the PTO, and I was thinking a lot about these issues. But it's true. Look, everything is cyclical. Industries, including the legal industry, is cyclical. For IP in particular, for a very long time, IP and patent law in particular was reserved for the specialist firms, the general practice firms, the non-IP lawyers thought of our field as something super esoteric that's best left for the geeky patent lawyers, with pocket protectors and so on. And for a long time, there was this symbiotic relationship where the big firms stayed out of it and referred matters. Whenever an IP matter came up, referred them to the boutiques. Until the late 70s, early 80s, I would say, firms began to see that IP is, quite profitable, can be for a law firm, and interesting, and that the lawyers, some of them do like it. And they began to get into it slowly but surely, one by one. And nowadays, most big general practice firms want to have a very meaningful IP practice. But you're right, Gene. That's generally true for litigation. The big general practice firms generally stay out of the pure prosecution type work, and that still gets referred a lot to the specialist firms. But when it comes to litigation, they want to do it, all of them. It's also true that the cycles continue, and some of the big practice firms that have gotten into it are having a difficult time figuring out exactly how to do it and how it fits with the rest of their practice. But that's not to say that some of the big general practice firms are very successful at it and are frequent flyers when it comes to IP litigation. But yeah, it's true. It's cyclical. I'll say one more thing. For a long time, IP litigation was viewed as a preeminent premier practice that commanded the top rates and required best-in-class lawyers and so on. And to some extent, this is still true in comparison to some other areas of general practice litigation. But at the same time, a lot of our work has become commoditized as well, which means that in the end, it's now less profitable than it was some time ago, some years ago. So that's also what's causing some of these bigger firms to rethink their approach.
So there's a lot there, really. I mean, one, I want to talk about the cyclical nature of not just the law firm business model, but just intellectual property in general. And then the other piece is to pick up, maybe we could pick up where you left off there about how a lot of the big firms want to get into it and they're often provide best-in-class representation. The cynical part of me thinks that you don't need to have best-in-class representation anymore, particularly on the defense side. All you have to do is yell 101, patent ineligible, and a big, huge chunk of the cases go away. And maybe it's gotten better on the invalidity front now with what's going on at the patent office, but therefore, most of the last 15 years, all you had to do is file something at the PTAB, and then even if it wasn't going to be a 101 in district court, you weren't going to have the patent at all because of the PTAB. So I wonder whether some firms and litigators looked at that and thought, I could see them looking at it in a couple different ways. One, this is just easy money. You get in and out of these cases very quickly. And obviously on the patent owner side, that's not the case. If you don't have good representation on the patent owner side, you got really no chance. Have you thought about that whole dynamic and how it's shifted? I mean, can you imagine when we were in law school? Because I think we went to law school at about the same time. If we had suggested to our civil procedure professor that there would be a motion to dismiss granted before anything was ever looked at, I mean, we would have failed the exam. I mean, that was just not the way it happened.
Or that the case would get stayed almost routinely pending some parallel administrative action again and again, which is what's happening nowadays as well. You're right in general on all of that, Gene. The reality is that for a defendant, there are many paths towards winning a case. 101 and early motion to dismiss that you just articulated is one such path. It works in a good number of cases, doesn't work in all the cases. But let's not forget all the other tools. Number one, again, just simple delay, just file a petition for IPR or reexamination. Case gets stayed for a long period of time. So that's just pure delay and perhaps losing completely, not in court, but at the patent office, and that takes care of the case. Then, you have to overcome, as always, judge and jury on infringement and validity. As a patent owner, plaintiff, you have to win on all of those things. Defendant just needs to win on one of them to get out of the case. That's always been the case, and that's just the way the system is set up. But then after this, then you have to overcome the federal circuit, and that has been increasingly more difficult, especially if there is a significant large win below. And as we've already discussed, you have to overcome events at the patent office. Again, a patent owner needs to be able to navigate all of these and win every single time to ultimately prevail, and that takes a long time. On top of all this, what's new that wasn't there when we graduated law school is that it's much more difficult to get an injunction. Even if you won all these things all along, at the end of the day, best case scenario, most of the time, is just money damages, not an injunction, not the ability to exclude in a patent case. That does not satisfy many patent owners who thought they got an exclusive right, but it also paradoxically makes for longer litigation and more litigation instead of less, because there is much less incentive for the accused infringer to settle and take a license. And you put all of these things together, it's making it significant. There are many more paths towards some form of victory for the defendant than for the plaintiff in a patent case. Now, to tie it into your first set of questions about law firms and the like, could just circle back a little bit. Look, it's still a difficult field, and even the defense lawyers, they do have more weapons than they used to in the past, but nevertheless, they still have to be skilled to deploy them appropriately and in the appropriate sequence and the like. And look, the issues are, the legal issues are not simple. Section 101 is not simple to navigate, claim construction, and validity and obviousness combinations and so on. So you still need very skilled lawyers on the defense as well as offense, of course. But why it makes sense still for a lot of large firms to be in the space is because they already have clients from other areas of practice, whether it's transactions or general practice litigation, that also get sued for patent infringement. So why not have a full service capability for those clients, especially now that they have figured out how to navigate these issues? And that wasn't necessarily the case a long time ago. So all in, it makes sense for the big firms to be in this space. It is still an important space. And because they're usually on the defense, the big firms are usually successful and the clients are happy with it, because defendants nowadays win quite a bit more often than plaintiffs at the end of the day.
Yeah, my cynical view, when I first started litigating at the beginning of my career, we used to say to the defense bar, you have friends on both sides of the aisle when you're litigating and you get to know people. Some people you don't want to know, but a lot of people are just, ordinary, everyday folks that are doing their job. We would give them a hard time. It's like, how would you do one day in your life with the ball and chain that is the burden? And I just wonder what happened to this when the patent side, there's always been the plaintiff has the ball and chain to prove the case. But my goodness, now we need to run a gauntlet. And it just seems to have gone so far against the patent owner that I don't recognize our patent system. I think the patent system of some other countries looks more like our patent system used to look like than our patent system currently is compared to what it used to be. And that just is, I find it just hard to stomach. And one of the things that we're going to start to do here now at IP Watchdog, I kind of starting to kick off this initiative, is since these bills don't seem to be going anywhere, and since the regulations and rule changes don't seem to really be going anywhere, I want to have a conversation about what is the patent system today and what should the patent system be, untethered to like para or prevail or restore. Now, I think all of those are great ideas, but they're obviously not going anywhere for some reason. So what can we do to create a better, in my opinion, more fair patent system that does recognize that at least some of these patents have to be valid, at least some of these patents have to be eligible, at least some of them have to be infringed. Oh, and by the way, when you run that gauntlet, if there actually is infringement, that there needs to be some kind of monetary reward, right? I mean, it feels like over the last 15 to 20 years, it's been a drip, 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 drip. I mean, if I made you king for a day, king of the patent system, where would you focus your efforts to make changes that would have the biggest impact?
This is a huge question, Gene, and we can spend easily the rest of this podcast and many more days and weeks and months on end discussing it. But it's a fantastic question. It's exactly the right thing that the IP community should think about. Look, the reality is that the bones of our IP system were created in the 18th century, shortly after. I mean, it's in the Constitution, right? The IP clause that we all know about in Article 1, Section 8, Clause 8. But then, the Patent Act of 1790, 1793, just overall, the bones were created at the end of the 18th century. And it's been revised every now and then, but it hasn't had a hard look really at the fundamental principles since then. And Section 101 is just, it's just an example, but it's emblematic of it. Because Section 101, as we know it today, word for word, was literally written in 1793 for that Patent Act of 1793. And at that time, it was a tangible economy. It was an agrarian economy back then, but doesn't matter. They was at the beginning of the first industrial revolution with the machines the steam engine and so on that began taking shape. And then throughout the 19th century, great boom in American innovation. But again, machines, with Edison and the light bulb and the telephone and so on, telegraph, and then the early 20th century, similar with the assembly line and automobiles and airplanes with the Wright brothers. But then at some point in the second half of the 20th century, we began transforming into an information economy, information-based economy, largely here in the United States and in large part throughout the Western free market world. And ever since then, we've been having a tough time fitting our traditional IP system into the realities of the new technologies. And now we are pretty much at critical inflection point where the information age is visibly under our own eyes, taking over everything with the advent of AI and the unbelievable growth in artificial intelligence, which is largely dominated by processing of data and humongous data sets, all of it intangible. You don't really have so much nowadays. The crux of the innovation engine in the United States, it's not so much what's in the 4 statutory categories from the late 1700s in our statute. Not so much machines, manufacturers, compositions of matter. Not so much that. And processes, it depends what you mean by processes, which is a whole point of debate. It's a lot more this data and the intangible. You can see it, you can touch it, the processing of that. Even in the biology side, the life sciences side, when you're looking at DNA processing and biotechnology, which is tangible in the end, you're engineering molecules and so on. But so much of that is based on statistical analysis of DNA information. Just information, massive amounts of DNA information being processed in very creative ways that creates unbelievable innovation. But nevertheless, a lot of it is information-based. So our systems, mostly on the patent side, but very similar phenomena on the copyright side, is having a tough time keeping up with that new technology. And the judges are having a tough time with that and can't really grasp it and fitting these new information-based technologies into the old statutes. And certainly the legislators and the administrators are having a very tough time as well. So I've been beginning to speak publicly quite a bit lately about the need to rethink everything, but the fundamental basis of how do we protect and continue to incentivize innovation in an intangible world. And anyway, so that's the premise. And those are the fundamental questions. Now, if you ask me, how would I do it? And the answer is, the first thing is easy. First thing I would do if I were king for a day would be, I would make it an exclusive right. That is in the Constitution. It's hard to understand what a patent is if it's not the right to exclude others for a limited period of time. We can talk about how limited that limited is. Right now it's 20 years, but it wasn't always 20 years. And by the way, in some areas it's different than 20. But anyway, we can talk about that and we can talk about other parameters. But first and foremost, you have to go back to the basic fundamental. It's the right to exclude. But from there is a lot to think about. And I would not propose that one individual or 5 individuals set the parameters. What I would propose is that we have to have a national conversation on it. Let's understand from the industries themselves what is needed. Let's have a conversation with the policymakers and the think tanks, and let's come up with the right parameters of exclusive rights that would incentivize and protect innovation for the 21st century. Congress needs to be involved, of course, but it first has to start with industry and with the experts in the field.
I agree. And we're going to try and facilitate that conversation here at IP Watchdog, because I think I think we have some time to do this, because I don't think we're going to get anything past this term. And if we don't get it this term, we're just losing too many interested members of Congress to retirement and or lost in the primary, or chose not to run, or going to run for a different office. There's not going to be, for the next few years, leaders in Congress who see IP as a core issue. We'll still have Senator Coons, of course, but we're going to be out in the wilderness for a while. We got to figure this out on our own, and I think we've got some time to do it, at least before it percolates back up to have any serious chance to get legislation done. So, but we got to be ready for it. And one of the things that I think too is, look, I'm not unsympathetic to the injunction issue. We had a program here last week at IP Watchdog, and Scott McEwen was saying, like, well, look, if Apple were facing 20 injunctions a year, the people would probably look at that very differently. And I look behind what he's saying, I get it, but I think there's a bigger piece here. And you may have just touched on it when you were talking about, in the past, we had, Edison and the light bulb, and the Wright brothers and the airplane, and there was an invention and a patent covered that invention. And you look back then, even probably 60 years ago, certainly 100 years ago, patents were one page of text, one page of drawings, and that was pretty much it. And everybody knew what the invention was, and everybody knew whether you were infringing or not. And somewhere along the way that changed. But now that we're in this information economy or digital economy, AI economy, increasingly, we have, for some of the most important inventions in our society, we have thousands of patents that relate to that product or service. And that's a different world. Now, I don't think it mean that it's not property, because if it's not property, then we know what's going to happen. They're not going to pay. They're going to stretch things out. They're going to infringe. They're going to efficiently infringe, which is just predatory. So there's got to be some kind of property right, some kind of right to exclude. But I also think we probably need to put our minds together, and this obviously will take some kind of legislation, but there's got to be a way that if you are one of the mega giant companies, Silicon Valley darlings, and you want to pay, you can pay and negotiate and not get held up. I get that. I understand that worry. I don't think it's played out nearly like we've been told it has. I think them preventing payment to the patent owner is really what's going on, not the patent owner holding up any inventions. But I can understand the concern given the shifting innovation landscape, meaning, one patent, one product, and now it's 10,000 patents for one product. So I think that what would you think about something like an ASCAP or BMI kind of model? I mean, because I think what they do is they say, well, there's 10,000 patents or 1,000 patents that we can't possibly pay everybody, so we're going to pay nobody and ignore them as if they don't exist. That can't be the model of the future. But I'm not sure going back to the NPT days are also the future, where BlackBerry was getting shut down. Nobody wants that again either. So where do we go in between?
Okay, so a lot to unpack in there, Gene, but it's exactly the right conversation that needs to be had. First of all, what's happening, what you're articulating, is that we're trying to fit 21st century technology into an 18th century paradigm, by and large, okay? And it's getting increasingly more difficult to do. And I think it is important, instead of continuing to our hand-wringing and our continuous complaints about patent trolls on the one side or efficient infringement on the other side, and all of these things that has come up over the last couple of decades, Instead of that, let's look at it with fresh eyes, think completely outside the box, and think about what is needed to incentivize and protect innovation and investment in that innovation that is relevant to the 21st century technologies. Okay, so that is so that's number one. Think about with fresh eyes and stop thinking that one side is bad for asserting too many patents, or another side is bad for fighting the assertion and not wanting to pay every time they're being sued. And bring a new perspective and ask fresh, new questions unburdened by old paradigms. In some areas of technology, the old system still works well. Okay. And not everybody will agree with what I'm about to say, but I do think that it still works well in the chemical arts and the, in drug development technologies, where it still is largely just a few patents, relatively speaking. I know people talk about patent thickets in the drug world, but the reality is, by comparison, there are just, few patents on a very complicated new drug and delivery mechanisms compared to other areas of technology. Those are still tangible. There's still long-term investments. 20-year protection makes a lot of sense. Once you have a drug, it takes years to get a drug to market. And once you have it on the market, the companies keep it out there for a long period of time. So these 20-year rights make a lot of sense still in that space. On the other hand, the very completely opposite direction, we have no rights at all for pure data and data sets. We patents don't apply there, copyrights usually don't apply. So you have basically no protection there. And then you have, things in the middle here, like you don't know, like software is very complicated, right? I mean, we do issue patents on software. We issue some copyrights on software. There's copyright protection on software. Nobody ever in Congress, nobody ever sat down to say, hey, what is software exactly? I don't know if it fits into the 18th century, machine manufactured process composition of matter. And I don't know if it fits into the literally, it's not a book, or it's not a poem, it's not a song. I don't know if it fits into the copyright. Courts have tried, and the administrators have tried to fit it into one or the other or both. Nobody even sat down in Congress to try to legislate here and say, hey, what is the appropriate right? There should have some IP right. But what is it exactly? What's the length of coverage that's appropriate? What's the depth of coverage that's appropriate? The reality is, for all the hand-wringing that's going on in the IP community, the reality is that some of these newer technologies, by the time the patent office picks up the application to even look at it for the first office action, they're on the third generation beyond. It's obsolete.
Absolutely.
Much less about issuing the patent years later and enforcing it. And it's fair to say, hey, does that system work for these new technologies? Does it do what the industry needs in that space? Again, it's really important to have IP coverage of some sort in a free market economy to allow for the investment in that innovation to be incentivized and protected when successful. But it's really important that we start asking what type of right would work well for those industries.
Yeah, I absolutely agree. And I listen to a lot of people I respect very much, and I'm not going to throw them under the bus. I won't even name them here right now. But for a long time, I've been wondering whether or not this one-size-fits-all patent system really works anymore. And I don't think it does. And I've kind of bit my tongue a little bit because people that were older and grayer than I, and probably a whole lot smarter than I'll ever be, would tell me, no, one size fits all. It really, because if we start going in and carving up the patent system, it's going to look like the tax code, which I think that's probably true. But I do think there's something there that, for example, why did the patent owner community not throw the real trolls, the people who are filing lawsuits and then trying to shake people down for nuisance settlements for, $20,000, $40,000, $60,000 before the settlement conference? Why did the industry not throw that part of the patent ownership industry under the bus? Because those are bad actors. Extortion is a bad act, right? I mean, that to me seems to be super easy. And then the patent owners never define, well, here's what's good. We're not that. Those people, we agree with you. We got to come up with a solution. But it was all this, we're going to die together. We're going to die on this hill together. And guess what? Well, look at where we're at right now. And the patent owner community has really just died on that hill. And that's just one example. I think there's a whole bunch of other things. And maybe it really does boil down to this, that, a one-size-fits-all patent system makes a lot of sense when we're dealing with 18th century and even 19th century and even maybe to some extent 20th century innovations. But it doesn't make a lot of sense for 21st century innovations to put the pharma people in the same bucket. And the patent thicket thing, I don't want to necessarily go down that. There are no thickets with drugs. And it's all based on a lie. And they count the number of abandoned applications and things that never wind up getting patented. And that's how they claim that there's a thicket. But these drugs, the only patent most of these drug companies care about is the composition. And there's one that matters, and it's the one that the FDA has allowed. I mean, so like you have the pharmaceutical industry, who the biggest companies in the world maybe have a couple hundred patents tops. Independent inventors are on a different boat. Even universities are in a different boat. Giant companies like Caterpillar, which, create something that you could touch and that is going to really change the world, but physically so. All those companies are in a different boat than the Apples and Googles and Samsungs of the world and the people who want to be their competitors in the next generation. And I think if we are not willing to acknowledge that and try and come up with, I don't know whether it's sui generis protection or whether it's a different level of patent or a different kind of patent or just a recognition that different industries need different things and therefore the laws need to be different. If we don't come to that resolution, I don't know where the U.S. patent system is going to wind up in another decade.
And and the reality is that by not coming up with sui generis rights or types of different types of IP protections for different needs, if we don't start doing more of that, some areas will have no protection at all, data being an example, and some areas that need the protection are going to be harmed by, such as in the drug area, they're going to be harmed by weakening the entire system to accommodate all comers in like fashion. So I think it is important, as I said, to start thinking out of the box. I have historically said, Gene, that I don't think balkanizing the patent system is a good idea for a variety of reasons. One being, it's hard to predict the future. As Yogi Berra said, predictions are difficult, especially about the future. And you don't know what technologies are going to keep coming and which bucket do you put it in. Okay. And the other concern I historically have had is that a lot of innovations cross over different genres. Let's assume you have an IP system on compositions of matter, for example, and a different system on software and data processing. Well, look at some biotech, the making of molecules. A lot of that and the analysis of DNA, a lot of that is biology-based, a lot of that is software-based and data-based. But I think those are now, I'm beginning to think that these are issues that can be bridged. And I began to urge people to, A, think in completely new paradigms, but B, understand that we have in the past done sui generis types of rights. We have. And some very successful, others not so successful. Let me give you some examples. We have an IP right for FDA data. For small molecules, FDA data, you get 5 years worth of protection. For large molecules, 12 years in the United States. That is separate from the patent rights that these, companies have. In addition to that, they have these data protection rights. It's tied into Hatch-Waxman. It's working really well for everybody. It's allowing the companies to make the right investments, which are very high, to generate new drugs and test them in lengthy and expensive tests. And at the right time, it's allowing the generic companies to come in. And the United States is a leader, worldwide leader for generic drug penetration. 90%, 9 out of 10 prescriptions are filled with generic drugs in the United States. That way outpaces the averages in the OECD and virtually every developed country that we know. So it works really well. It's a sui generis right. I'll give you another example. We have plant patents. It's actually a patent that is being processed and administered by the USPTO, but it's different. Different length of protection, different statutes, different requirements. It's just different. It works well. And by the way, it's very unique. It's only for asexually reproduced plants. There is another type of IP right for sexually reproduced plants that's administered by the Department of Agriculture, not by the USPTO. It's a different right. Now, in addition, I'll give you an example of something that hasn't worked really well. We had a sui generis IP right for mask works. Do you remember this?
Mm-hmm.
There was a act of Congress. There was a lot of brouhaha about it. I don't know, 20 years ago or something. It's not being used very much. Folks should realize that the country has had experience with sui generis rights. Why not do it again now, where we have such important brand new type of technologies, like the large language models and the all the AI that's being used and the data processing, the unbelievable amounts of data that we have, and everything being so information based. Why not have a new look at that and see what industry really needs there and what it would make it work for them?
I agree. And, on some level, design patents could fall into this as well. I mean, you either need design patents very, very much, or they're completely and totally irrelevant to what you do. But if you need them, they are the only tool in your toolbox that will provide that particular protection against knockoffs and counterfeits to a lesser extent, but the knockoffs really, right? And so we have all kinds of this experience. I think it would make sense to go down this path. I used to joke around, I've taught the patent bar review course now for, it's hard to believe it, 27 years. I mean, my goodness, where has time gone? But I used to joke around, since I was doing software, John White would have to do the patent term adjustment and patent term extension part of the lecture, because I know nothing about it, because by the time you get to the end of the patent, software is completely obsolete, and if it's not obsolete, that's like the unicorn kind of innovation. I used to joke about that. Now, as you say, with some of these AIs, like, stick around, it's going to be different next week. I mean, it's different literally quarter to quarter. What goes on this year now compared to what was going on last year, it's like almost an entirely different product. So the patent system is just not fast enough to do anything about that, unless what you've come up with is a foundational platform. And, I don't know, even then, how long is it going to be any good for in terms of being really commercially relevant? I think we need to get more nimble. We need to look at what protections are going to get people to invest, because without investment, none of this happens. Because increasingly, innovation that we want, it's not just a few $100,000. It's not just a few $1 million. It's tens or hundreds of millions of dollars. And in some cases, billions of dollars need to be invested. And as Jay Walker, the founder of Priceline, famously said, he told me and others years ago when he was still in the game and doing interviews and so forth, he said, you simply cannot invest in what you don't own. If you don't own it, it's not investable. And I don't understand why that fundamentally isn't the starting place, and people don't understand it. By I say people, I say policymakers on the Hill. Some bureaucrats don't get it either. And I'm really, really fearful increasingly that judges on every level, at least in the US, don't understand that.
Yeah. I don't think they do fundamentally at the broad level, mainly because I don't fault them or the system. They're really struggling to, again, fit this new technology and the events in the current industry that are taking place under our own eyes into a very old paradigm. And they're struggling with that. And some get it right, some get it wrong. But I just want to add something very important to what you just said. So a key is to get people to have a system that gets people to invest in innovation. And that's really important, obviously, because innovation is inherently risky. Most of it doesn't work. But when it works, it needs to be protected because it's usually easily replicable. So in order to get folks to the table to invest time and money and energy and creativity, there has to be a system to incentivize that and protect that. But at the same time, a parallel goal of any IP system is the quid pro quo of that, which is getting the innovations and new technologies to be shared publicly. That is always the fundamental quid pro quo of an IP system. On the one hand, get folks to come up with the new stuff and be creative. And on the other hand, get them, incentivize them to share it with the public really as early as possible. Because that's what allows for the dynamic growth and exponential growth in innovation and creativity. And it's worked really well for this country for the past 250 years. And there are some systems, trade secrecy is an example, where there, in some areas, having strong trade secret rights is actually very helpful to the investment part of it. Because you're going to invest and you can protect it, and you're not so much afraid that somebody's going to steal it. And if they do, you can punish them and all of that stuff. So that's important. But at the same time, that does not allow for the sharing of the with the rest of the public. And when that happens, the big ones get bigger, big entities get bigger, and it prevents the upstart and the innovators in the garage from challenging the status quo, and it does not allow for this dynamic growth in innovation. So any new system we design, just like the original system, needs to have these two components: the incentive and the protection of innovation and investment in innovation on the one hand, and the public sharing on the other hand. This is an example of this you can see right now playing out with data in the United States. Because there is no IP right here other than trade secrecy, most companies guard their data sets with utmost jealousy, and it's like their crown jewels, very little sharing. So that enables the companies that have the biggest data sets to train their models, the AI models, at scale and really outperform the little guys that start and they don't have enough data. It allows for the big to get bigger, and makes it difficult for the little guys to penetrate and to trade on this really critical information and data and knowledge.
And that is a huge problem, the big getting bigger and the little. I mean, look, I have nothing against the Googles of the world, Apples, all these big giant companies taking a position that benefits them, lobbying them, advocating for them in the courts and in the halls of Congress. But let's not forget, all of those Silicon Valley darlings were at one point in time either two people in a garage or two people in a dorm room. And they started small and they grew. Google's a great example, the prototypical example. Apple is another example of those two people starting with a dream and moving forward. And I just fear that our innovation policy, particularly our patent policy, but our innovation policy at large, is not nearly as advantageous as it has been historically or should be moving forward for the small entities who are the risk takers, who are the ones that create the overwhelming number of jobs in the U.S. and who drive our economy. I think we have it exactly backwards.
Right. And as you said, you can't fault them for following their business interests, as any company leader should. And on top of that, let's just remember, they're working within the system that we have. And I don't know, I want to hear from them and from all the innovators in the 21st century technologies. What is it going to make them be more innovative, to invest even more in risky new technologies, and to, at the appropriate time and under appropriate circumstances, share it with the public? Because that's what the basic patent is. Same with copyright, in some ways. You have the protection, you're sharing it with the public, others can improve upon it right away, and eventually others can do exactly what you have disclosed when the patent expires. Same with data rights protection for FDA data, the 5 and 12 years that I've mentioned for drug development. It's the same kind of a principle, is that quid pro quo. You have limited time of protection. You can use it, but only in limited ways. And then when it expires, it's a free-for-all. And I don't know exactly what it is, but those two ingredients need to be there. But what does it look like for these new technologies? That is the conversation that needs to be had with industry, with folks should come to the table from all corners of industry and put their views on the table. And in the end, because this is the way this country is designed, ultimately, Congress needs to legislate, and they need to do their job and create a system that's going to work for this country going forward.
Well, from your lips to God's ears, I hope that happens. And I really appreciate you being here. This is a fascinating conversation. Hopefully you'll come back and we can have more of this conversation and see what happens as we try and move things forward in a productive way.
A pleasure, Gene, as always. Always happy to come and be with you.
Thank you for listening to IP Watchdog Unleashed. We will be back next week, and we hope you will join us again. In the meantime, please be sure to visit IPWatchdog.com to read all the latest news and information about what is happening in the intellectual property world. And also be sure to subscribe to our free daily email newsletter.